1 year into his second term, Donald Trump has achieved something no American president has managed before. He has turned the federal judiciary into a battleground, provocation into policy, and contempt for the law into a governing philosophy. The man who entered office as a convicted felon, sentenced just 10 days before his inauguration, has spent 12 months treating court orders as suggestions, judges as enemies, and the Constitution as an inconvenience to be steamrolled whenever it blocks his agenda. He has called for the impeachment of judges who ruled against him. His administration has filed misconduct complaints against jurists doing their jobs. His deputies, according to whistleblower testimony, discussed telling federal courts to go to hell when orders came down they did not like. And through it all, Trump has operated with the assumption that the presidency grants him immunity from accountability, from consequence, from the basic principle that no one in America is supposed to be above the law. That assumption is about to be tested. The courts Trump has attacked, defied, and demeaned are now closing in. The collision between executive power and judicial authority did not begin as an abstract constitutional debate. It began with planes in the air and men in chains. On March 15, 2025, Trump invoked the Alien Enemies Act of 1798, a wartime statute that had been used only 3 times in American history, all during declared wars. Trump claimed that Venezuelan gang members constituted an invading force, and that the law permitted their summary deportation without hearings, without lawyers, without the due process protections that have defined American immigration law for over a century. Within hours, planes carrying more than 200 men were airborne, headed for El Salvador's notorious Secot prison, a facility designed to hold terrorists in permanent isolation. Federal Judge Judge Boasberg, the Chief Judge of the U.S. District Court for the District of Columbia, moved quickly. He issued a temporary restraining order blocking deportations under the Alien Enemies Act. When government lawyers informed him that planes were already in flight, Boasberg issued an oral command: turn them around, bring them back. The directive was clear. It was communicated to the officials overseeing the flights. Flight tracking data confirmed the planes had not yet landed. The planes did not turn around. Hours later, El Salvador's president, Nayib Bukele, posted on social media. Above a news headline referencing Boasberg's order, he wrote 2 words: "Oopsie." Too late. Secretary of State Marco Rubio retweeted the post. The message from the administration was unmistakable. They had defied a federal judge openly and gleefully. They were proud of it. What followed has become the most consequential confrontation between a president and the federal judiciary since Watergate. Boasberg hauled Justice Department lawyers into his courtroom and demanded answers. Who made the decision to continue the flights? Who communicated the court's order? Why was it ignored? The government's responses were evasive. Attorneys cited attorney-client privilege. They claimed the judge's oral instructions were not binding. They argued the written order lacked sufficient specificity. Boasberg was not persuaded. In April, he issued a 46-page opinion finding probable cause to hold the Trump administration in criminal contempt of court. The language was extraordinary for a federal judge addressing the executive branch. He wrote that the government had demonstrated willful disregard for his order. He accused officials of stonewalling and increasing obstructionism. He noted that boasts by administration officials intimated that they had defied the court's order deliberately and gleefully. And he quoted the Constitution. The Constitution does not tolerate willful disobedience of judicial orders, especially by officials of a coordinate branch who have sworn an oath to uphold it. Trump's response was to call for Boasberg's impeachment. Chief Justice John Roberts, in a rare public statement, pushed back. Impeachment, Roberts said, is not an appropriate response to disagreement concerning a judicial decision. The rebuke was notable for its directness. Roberts has spent years attempting to preserve the appearance of judicial independence and institutional legitimacy. Trump was forcing him to defend principles that previous presidents had taken for granted. The contempt proceedings did not move forward smoothly. 2 Trump-appointed judges on the D.C. Circuit Court of Appeals intervened, issuing an administrative stay that froze the case for 4 months. During that window, Emil Bovey, the Justice Department official who, according to whistleblower testimony, had told colleagues they might need to tell courts to go to hell, was confirmed to a lifetime appointment on the Third Circuit Court of Appeals. The Senate vote was 50 to 49. No factual record from the contempt proceedings was available for senators to review. In November, the full D.C. Circuit reversed the stay and allowed Boasberg to resume his investigation. The judge announced he would call witnesses under oath. He identified Erez Ruvani, a former Justice Department attorney who had since become a whistleblower, as a likely witness. Ruvani had told 60 Minutes that Bove emphasized in a meeting that the deportation planes needed to take off no matter what, and that if a court issued an order preventing that, the administration might have to consider telling that court, using the full obscenity, to disregard itself. The administration responded by attempting to have Boasberg removed from the case entirely. The Justice Department filed a motion accusing him of retaliation and harassment and claimed he had developed too strong a bias to preside impartially. In December, Trump-appointed judges on the D.C. Circuit again issued a temporary pause. As of January 2026, the contempt proceedings remain in legal limbo, with the administration fighting to prevent any Trump official from testifying under oath about what happened on March 15th. The pattern is clear. When courts rule against this administration, the administration does not comply and appeal. It defies and attacks. The Boasberg case is not an isolated incident. It is the most visible manifestation of a systematic assault on judicial authority that has defined the first year of Trump's second term. According to the Lawfare litigation tracker, 253 active cases are currently challenging Trump administration actions on national security grounds alone. The Just Security Tracker documents hundreds more across all policy areas. By one count, at least 225 federal judges have ruled in more than 700 cases that administration policies likely violate the law or constitutional due process requirements. These are not activist judges in blue states. They include Trump appointees. They span every circuit in the country. The breadth of judicial resistance is unprecedented. The administration has responded not by moderating its positions, but by escalating its attacks on the institution itself. In June, the administration took the extraordinary step of suing all 15 federal district judges in Maryland over a standing order that slowed deportation proceedings. The lawsuit was eventually dismissed, but the message was delivered. Judges who rule against us will face consequences. Threats against federal judges have spiked. According to U.S. Marshal Service data, there were 564 threats against judges in fiscal year 2025. Since fiscal year 2026 began in October, there have already been 131 threats, a pace that would exceed the prior year if it continues. Judges handling cases involving the Trump administration report that threats have become even more prevalent and more specific. Senator Ted Cruz held a hearing in January 2026, explicitly calling for Boasberg's impeachment. Republican lawmakers have introduced impeachment articles against multiple judges who have ruled against administration policies. The campaign has drawn condemnation from across the legal establishment. Retired Judge J. Michael Luttig, a conservative icon who was a mentor to Cruz and a protege of Justice Antonin Scalia, submitted a written statement calling the impeachment push contemptible. He wrote that Professor Robert Luther's testimony, urging Boasberg's removal, should be dismissed as singularly unhelpful to the committee in determining its sacred duty under the Constitution. Meanwhile, the legal exposure Trump carried into office has not disappeared. It has merely been deferred. Trump remains a convicted felon. The New York hush money case resulted in a guilty verdict on 34 counts of falsifying business records. Judge Juan Merchan sentenced him to an unconditional discharge in January 2025, imposing no prison time, no fines, and no probation. Merchan cited Trump's impending inauguration and the need to respect presidential immunity during his term. But the conviction stands. It is on his record, and Trump is actively appealing it through multiple channels. In November 2025, a federal appeals court ordered the district court to reconsider Trump's bid to move the case to federal court, where he hopes to have it dismissed on immunity grounds. The Manhattan District Attorney's Office filed a response in January 2026, arguing that the conduct at issue, paying hush money to a porn star to influence an election, was based on wholly private, unofficial conduct and should remain in state court. Judge Alvin Hellerstein, who has twice denied Trump's removal requests, must now rule again. Simultaneously, Trump is appealing his conviction in New York State Court. His lawyers filed their brief in October 2025, calling the prosecution the most politically charged in our nation's history, and arguing that testimony from White House aides should have been excluded under the Supreme Court's immunity ruling. The state appellate court has not yet ruled. The E. Jean Carroll defamation case continues to follow Trump as well. A jury awarded Carroll $83.3 million after finding Trump liable for defamatory statements. The verdict was upheld on appeal. Trump has now asked the Supreme Court to review the case, arguing that testimony from other women who accused him of sexual assault should have been excluded. Carroll's attorneys filed their opposition brief in January 2026, arguing that the testimony was properly admitted and that the verdict should stand regardless. If the Supreme Court declines to hear the case, Trump will owe Carroll nearly $90 million in combined judgments. He has already posted bond to delay collection, but the financial exposure remains. The Georgia election interference case, once considered the most serious legal threat Trump faced, was dismissed in November 2025 after the prosecutor who replaced Fani Willis declined to pursue charges. Pete Skandalakis, the new special prosecutor, filed a 23-page motion arguing that the indictment was too sweeping and that prosecuting a sitting president was impractical. Judge Scott McAfee granted the dismissal. Trump celebrated on Truth Social, declaring that justice had prevailed. But dismissal is not exoneration. The underlying conduct, the alleged conspiracy to overturn Georgia's 2020 election results, remains documented in the public record. The recorded phone call in which Trump pressured Georgia Secretary of State Brad Raffensperger to find 11,780 votes has not been erased. The testimony of election workers who were targeted and threatened has not been forgotten. The only thing that has changed is that no one will be held criminally accountable while Trump holds power. The federal cases were dismissed even earlier. Special counsel Jack Smith dropped both the classified documents case and the January 6th election interference case after Trump won the 2024 election, citing the Justice Department's long-standing policy against prosecuting sitting presidents. The policy is not law. It is internal guidance. It could be changed by a future administration. But for now, it shields Trump from federal prosecution until at least January 2029. What happens after that remains an open question. The Supreme Court's immunity ruling in Trump v. United States fundamentally altered the legal landscape. The court held that presidents enjoy presumptive immunity for official acts, even those taken in bad faith or for personal gain. The ruling did not grant absolute immunity for all conduct. Private acts remain prosecutable. But the line between official and private is now subject to interpretation, and Trump has aggressively claimed that nearly everything he does falls under official authority. The coming months will test that interpretation. The Supreme Court has agreed to hear cases on 3 major administration policies. The Birthright Citizenship Executive Order, which seeks to deny citizenship to children of undocumented immigrants born on American soil. The sweeping tariffs Trump imposed under emergency powers. And his attempt to fire Lisa Cook from the Federal Reserve Board of Governors. In all 3 cases, lower courts have ruled against the administration. In all 3 cases, justices appeared skeptical during oral arguments. Rulings are expected by June. Legal scholars note that the court has a historical pattern of waiting until a president's political strength has waned before delivering major defeats. Trump's approval rating has declined throughout 2025. The December NBC News poll showed 42% approval and 58% disapproval. The midterm elections in November 2026 loom large. A court that has been largely deferential to this administration on emergency matters may be less accommodating when issuing final rulings on the merits. The question is whether any of it will matter. Trump has demonstrated repeatedly that he views legal defeats as political opportunities rather than binding constraints. He attacks the judges. He rallies his base. He claims persecution. And he continues doing whatever he intended to do, daring anyone to stop him. The Boasberg contempt case will determine whether there are any enforceable limits. If the administration successfully blocks the proceedings, successfully removes Boasberg from the case, successfully prevents any official from testifying under oath, then a precedent will be set. Presidents can defy court orders without consequence. The separation of powers becomes an academic concept rather than a functional restraint. If Boasberg prevails, if officials are compelled to testify, if the evidence shows deliberate defiance, if criminal contempt referrals are made and somehow prosecuted, then the system will have demonstrated that it still functions, that courts still matter, that the rule of law is more than a slogan. No one knows which outcome is more likely. The machinery of accountability has been stress-tested before, during Watergate, during the Clinton impeachment, during the first Trump administration. It bent, but did not break. This time, the stress is greater. The defiance is more open. The political polarization is more intense. And the Supreme Court has already signaled that it will not intervene quickly or decisively against executive overreach. Trump entered office as a convicted felon. He has spent his first year attacking the courts, defying their orders, and claiming powers that no previous president has asserted. He faces ongoing civil judgments totaling nearly $90 million. His criminal conviction remains on appeal. His administration is under investigation for contempt. And he has 3 more years in office during which he cannot be criminally prosecuted under current Justice Department policy. The legal reckoning, if it comes, will come later, after his term ends, after he no longer controls the Justice Department, after the judges he has attacked and the prosecutors he has threatened have the opportunity to act without presidential interference. Whether they will act, whether the system will hold anyone accountable, whether the principle that no one is above the law still means anything in practice, those questions cannot be answered today. They will be answered by what happens next, by what courts do in the remaining months of 2026, by what voters decide in November, by what prosecutors and judges and citizens choose to accept or reject as normal. The record is being written. The evidence is accumulating. And somewhere in the federal courthouse in Washington, D.C., Judge James Boasberg is still waiting for answers about what happened on March 15, 2025, when planes carrying men to a Salvadoran prison kept flying, despite his order to turn around. The administration has spent a year trying to make sure he never gets those answers. The next chapter will reveal whether they succeed.